just to let the current attendees know that the reason why there's a silence is we're just waiting for exactly quarter past or perhaps a minute thereafter to allow you all into this link, and then we will promptly start. Hi, everyone. Thank you so much for joining this particular webinar. I know a lot of you have just joined and some of you are joining as I speak now. Just to introduce everybody on this webinar, first and foremost, we have, and I'll take it from the order of speakers. We have Simon Craddock from Brethton's LLP. We also have Alison here from Bindman's Solicitors. We have Forum Shah from Dawson Cornwall, and we also have Helen Blackburn from International Family Law Group. Now, today we will be discussing the topic of the inherent jurisdiction, and we are very lucky to be blessed with such speakers who are specialists in this area of the law, and they deal with all aspects of the inherent jurisdiction, from child abduction to disputes relating to public law proceedings, and even disputes that often arise sometimes in private law proceedings. And so the focus will be that of children and proceedings in respect of the inherent jurisdiction. And the target audience for this, I know a lot of you have joined this, and a lot of you are from all different backgrounds, all different experiences, some at the bar, some solicitors, some I know even from the judiciary have joined this. And now the ultimate focus will be to talk about some of the topical areas, some of the recent developments and things that we think will assist you all in your practice as a lawyer, or if you have a general interest in proceedings relating to the inherent jurisdiction. And what I will say is, just from the outset, one of the reasons why I really wanted to organise this event, and we also like to thank 4PB for the assistance in arranging it, and also Carla, the association that has assisted us with this, is I published 2 books last year in 2023. Firstly, in respect of stranded spouses, and then the second one in respect of the inherent jurisdiction, which we are going to be discussing now. And in essence, one of the things I want to say from the outset is I am going to give away, I think, 2 free copies of this book. So if anybody on social media tags any of us into any post following from this event, somebody will randomly select someone. Or the alternative way to win a book is the first person who can correctly identify Simon Craddock's age will also win a book. So do let us know in that respect. So what I'm going to do now is I am going to not introduce the topics that we're going to be talking about, and I'm going to allow it to flow. And I will go firstly over to Simon, who's going to speak to you about an important aspect in respect of the inherent jurisdiction proceedings.
Okay, thank you, Mani. Thank you, everyone. So yeah, I've been given the task of speaking for about 10 minutes on 4 points. So I will start things rolling. I'm looking at really inherent jurisdictions for child abduction, procedure. So Mani asked me the first thing, procedure for commencing applications. So without insulting people's intelligence, that is a C66 and a C1A. I think for cases that involve inherent jurisdiction, I think it's more important personally to flesh out your C1A, your harms point, than if it was a Hague Convention, because Hague Convention is primarily that there's been the abduction. As we are aware, the inherent jurisdiction is more welfare-based and therefore more important to think about domestic abuse, coercive control, etc., etc. In terms of legal aid, there was a good legal aid guidance last year giving guidelines as to whether you can issue inherent jurisdictions. proceedings and get legal aid for them. And so really the issues are, one, you need to be financially eligible. So the same rules apply as domestic. I would absolutely not go for granting delegated functions for somebody who was self-employed, for example, who wasn't on universal credit. And I would actually want to get a full public funding certificate. You don't need domestic abuse, as with mainline legal aid. And also the guidance says two other things. One, if you're going for something where there could be an outward Hague and you've issued proceedings because you're very worried, you need to explain why it is so urgent that you need to issue inherent jurisdiction proceedings in the High Court rather than go through ICACU to seek an outward Hague return form. And then the other thing is also they want to know that if you're seeking a return from another jurisdiction, non-Hague jurisdiction, and that's why you've issued inherent jurisdiction, they want to know the enforcement chances. So, for example, it may be that the person's left assets in this country, and therefore you want to sequestrate those assets, etc. So then I was asked to say, the TIP staff, who are they? So Mani has put in his book that the TIP staff possess the ultimate experience in all matters relating to abduction and other risks associated with matters in the High Court. I have also discovered, or obviously probably maybe knew this already, that the FDR, Practice Direction 12D, has a whole 7.1 to 7.4 on it. My favourite one is 7.3 that says there is only one TIP staff. And for those that don't know who he is, he's Richard Cheesley, MBE. And earlier this week, I was brave enough to pick up the telephone to Richard and seek his advice and guidance on what I should say in this talk and what were the main themes. Some of which would quite surprise me, actually, because for reasons that may become apparent later on, I actually do not, as a guidance, my personal self, go for many location orders and passport orders if I can avoid it, and certainly don't for collection orders. And he said that more often than not, he felt even in child abduction cases that the passport order was still the main order that is sought, as opposed to just issuing the proceedings on notice, which I have to say I was surprised about. He also said, good news for those that have been chased for getting orders, because the TIP staff is now going to, as of 3 weeks ago, draft their own orders, so their own passport and location orders, which is good, because if you're anything like me, you get chased, why haven't you got this order, etc. And you say, I haven't got it because the associate hasn't done it. So at least now we're just in charge of coordinating what the associate's doing and what the TIP staff's doing. They won't be involved in any ongoing orders, the refreshing orders, which makes sense, but that was useful. He also said, again, which surprised me, that after the hearing, the case of A versus B 2021 by Mr. Justice Mostyn with standalone port alerts, that they are actually quite popular in certainly in the provinces. So that's where you've got a prohibited steps order, and then you want to have teeth. They only last for 28 days. And they're only effective for a risk of people abducting children outside in England and Wales. So they will only really assist you in border checks, outgoing border checks. So if you get there in time, that's why they're quite useful. So I was surprised by that as well. I didn't think they would be used that often because the fact that they're 28 days, etc., etc. So that's that bit. What do solicitors need to do with the TIP staff? Well, if Richard Teasley, MBE, is listening, it'd be very nice to them, that would be the first bit, because obviously they are very powerful, they have an important job to do, and they are very rules conscious, and you need to make sure that you use the standard precedent orders to get names right exactly and set it out and make sure that your orders are compliant with TIP staff aspect of the order. Otherwise, they'll be sent back and there will be a lot of hassle and grief that you do not need. So then we come to the types of order that the TIP staff can make and for what purpose. So if we go back into the glory days of about 12, 13 years ago onwards, it used to be a standard thing. You just used to rock up at court, ask for your ex parte location order. Apart from one or two grumpy judges, it would be granted as of right. The tipstaff would make the order. Happy days. And then since then, over time, that has stopped, as we all know. And it is, as I said, a passport order that is more prevalent. Now, what they are is they are what they say on the tin. So a location order is an order seeking to locate children that are in the jurisdiction but are missing. Tends to be in tandem with disclosure orders. So when you issue these proceedings, you make orders against, for example, the Department of Work and Pensions, the schools register. And then once you've discovered where they are, you will then have those orders, the location, the passport order or the location order will be affected. The location one is served on the person who is the abducting parent or anybody who the tipstaff feels may know the whereabouts of that child, and they can have punitive consequences if they are breached. So the person that is served with a location order must say where they think that those children are being held and where the parent is. And it does mean for the consequence that that person, unless you seek to vary it, has to reside, and those children have to reside at that address pending the resolution of these urgent inherent jurisdiction proceedings. Passport order, again, it's about going to the person's property, getting the passport, taking them, securing them. They're both backed with a port alert, which means that until the next hearing, which means that it will be very, very difficult for that person to leave the country. With passport orders, again, there are punitive consequences if they don't comply. So I don't know about you, but I've had cases where people have accidentally on purpose forgotten to hand over their IDs for international cases, and et cetera, et cetera. And then collection orders, I've done, I think, one in my time, very rare, but obviously where somebody ordinarily has got a significant mental health issue that will impact on the immediate care and of the children, and there's a significant risk to the children being harmed, or you're looking at a sort of a case from abroad where they've been a foster care arrangement, the local authority have been involved, and then they come out, then they ask for immediate return. So they've skipped the care proceedings, absconded, and you're then seeking a collection order. Then what I would say is, in terms of, Mani's asked me to talk about renewal and discharging of orders. So again, tipstaff is very hot on making sure that the wording and the renewal's there and that you sort that out properly. And then the danger is once you've finished the case, you breathe out. And again, you need to make sure your order has all the discharging of orders, handing back of the passport. If you're acting for the applicant and you're seeking a return of a child to another country, you need to liaise with the tipstaff, make sure that the orders are in place, make sure the port alert's taken off, make sure that your process server or whoever's going to hand over the documents at the border, make sure that the person goes back to the country with the children. So I'm going to quote now from a 2012 case called B versus A. I call it something else for reasons that may become apparent. This is Mr. Justice Charles, and he says tipstaff orders and thus location orders are designed to be powerful weapons in the search for children and the determination by the courts of England and Wales of issues relating to their future. They enable public authorities to interfere in the private lives of adults, and they are therefore, the private lives of adults, and I've missed my place here, and children, and carry serious penalties. It should be known to all judges who grant them. The experience have shown that the travel time of a flight to England can often allow for steps to be taken to meet the relevant adults and child at the airport on arrival. The orders can be triggered when an adult comes to the notice of the police for some other reason, e.g. a motoring offence. And these possible triggers to an order mean that care needs to be taken to ensure their enforcement, and so possibly an arrest and detention on them, only remains a possibility for as long as they are needed to fulfil this purpose. The potentially serious impact of such orders means that those who apply for them and those who grant them should act with caution and due regard to the principles. Now, I'm going to let you into a bit of a secret now, because when Mani asked me to do this, it let me into a cold sweat, because this case was the nadir of a not so stellar legal career of mine, because I ended up getting a wasted cost order. Not me personally, the firm, but I was the person that was in charge of the case. Mr. Justice Charles, I won't bore you with the facts, but he went after everybody in that judgment, but primarily, sadly, Bretherton's. He said, as will appear later, significant parts of the grounds relied on to support such applications for costs reflect endemic failures by practitioners and judges of the family division. Yeah, he didn't spare his fellow High Court judges to apply the principles and procedures relating to without notice applications. Then he said, he showered some faint praise, maybe a slight drizzle, because he said, in my experience, the counsel and solicitors in this case are among the better practitioners who hold themselves out as specializing in cases of this type. And I recognize, and then the next bit I obviously agree with, because he said the endemic natures of the failures in this case to comply with the relevant procedures and practice has the consequence that it can be said that it would be harsh to pick on the particular practitioners for criticism or to penalize them or their clients in costs, as the respondent, through their advisors, asked me to do. Then he criticized the respondent for not making the applications there. And then he says, for these reasons, I have decided not to identify the solicitors and barristers in this judgment. But for me personally, 11 years have elapsed. I mean, in 2010, 12, Mani Basi was still dreaming of playing up front for Notts Forest. And I need to set alight the warehouse of resentment that I built up. Life moves on. But I would say in doing this seminar that I feel as though in one small, very perverse way, I may well have been part of the reason why these orders have been tightened up since that time. So thank you.
Thank you so much, Simon. And there you go for everybody. A real life experience and warning in respect of the importance of getting these provisions right. And before I transition on to Forum Shah, who would talk to you a bit more about these types of issues, I think it's really important to emphasize that in general terms, these orders, there was a decision of Mr. Justice Cobb, I think in 2019, that talked a lot about tipstaff orders and the impact and the effects it has upon the rights of everybody involved in the proceedings, but particularly those who are subject to the orders. And so it's very important to get it right. And so on that note, I will now go over to Forum, who will speak to you a bit more about some tips and views that she has through her work as a solicitor at Dawson Cornwall LLP.
Hello everyone, it's nice to see you all online, and thank you, Mani. Just before I start, I always say to everyone that I don't know where you find the time to write books and have a full practice, but I would recommend highly your book to anyone thinking about starting out in this field of law or just wanting a refresher. It's really, really helpful. Just following on from Simon, you heard from him about what the inherent jurisdiction is and the general procedure. I'm just going to be talking about a couple of provisions relating to the inherent jurisdiction from a child abduction perspective. So Simon's spoken to you about how to start an application before the High Court utilising the inherent jurisdiction. One of the things that you need to have regard to is on what basis you start the application off, i.e. is it without notice to the other side or is it on notice? That sounds quite obvious, but it's really important to get it right because it can be where things can go wrong, and this can have repercussions for later down the line in the case. So as I've just said, there are two main options, either without notice, so you don't tell the other party that you're going to court, or on notice, i.e. you do tell them. And picking up from what Simon said, I think I agree. There has been a huge sea change in how these applications are commenced. So I would say pre-2018, everyone would go off to the High Court. You'd see all your friends in the corridor. Everyone was making an application without notice, and you'd essentially have a nice morning out. But now that has very much changed, and you have to be extremely careful that an application is not made ex parte when the court then deems that it shouldn't have been. Judges are a lot more critical of this. So the first thing you should have regard to is the President's practice guidance regarding the case management of abduction proceedings, and that outlines the rules. There's a 3-step test there, so you should always go back to basics. So is your case of exceptional urgency? Is there a compelling case that the child's welfare could be compromised? Or C, do you not know where the prospective respondent or the child are? Because if you don't, then obviously you have to start off without notice to them. So I think you really need to work hard on your originating statement and really drill down into why an application should be made without notice if that's the route that you're going down. And I think we always we have a duty to our client to put forward and act on their instructions, but we also have a duty to the court. We need to be clear about what the evidence is, where you've obtained it from. And I think I agree with Simon. I haven't made many ex parte applications in the last few years, but where I have, I found myself pondering this question quite a bit because it is quite tricky. And in the end, I think it's really useful to do a balancing exercise of the pros and cons, and you can outline some of that in your statement to show the judge that you've really grappled with this question. And it's not an application that you've just made willy-nilly the day before it's not a statement that you've just prepared without giving thought to this. So ultimately it's the judge's order, but if you can show that you've grappled with the question, then I think that will give you a lot of brownie points. It's also important to note that short notice can suffice. So that could be 24 or 48 hours notice rather than the usual sort of 7 to 14 days. All of this will depend on the evidence before the court. But if you can show that you've given 24 hours notice and you can satisfy that there's not an abduction risk, for example, you don't think the respondent will have the means to get together funds for a flight, or to that particular location there isn't that many regular flights, then you could get away with notifying the respondent by email and writing. Especially if you know that that email address is active, you can give them notice and say, I'm going to go before court number 48 tomorrow at 10:30 a.m. Please attend. And that will also win you a lot of brownie points with the judge. And as Simon outlined, if a tipstaff order is also being sought, so for example, the tipstaff passport order or location order, then you need to ensure that you have contacted the tipstaff prior to the hearing. Their contact details are on the RCJ website Family Division page. And now a tipstaff order is quite a big interference with someone's right to life. So, for example, service of a tipstaff order at home in front of children can be quite scarring, same as if you are being served on an aeroplane or at the airport. That can also be hugely scarring. So it's really important that we consider this, and orders on an ex parte basis are only applied for where absolutely necessary. So now I'm also going to talk about a case. It's the case of ES versus LS from 2021, and it was a case that I was involved in where I acted for the respondent. And Mr. Justice Mostyn set out in that case that he didn't think requirements for a without notice application were followed, as he felt that it was really obvious that the father knew where the mother was. And in his own unique style, he commented as follows. So case law has emphasised the adverse consequences for litigants and their advisors if the requirements are not observed and applications are made which are wanting in candour or otherwise improper. In the administrative court, there has been for years gross abuse of the immediate facility. Sanctions are melted out to delinquent practitioners who seek to gain an illegitimate litigation advantage by making spurious, one-sided, urgent applications. The usual sanction there is a summons to attend a public sitting of what is known as the Hamid Court in order to be openly and shamingly admonished. Historically, in child abduction, it was considered acceptable, almost normal, to start virtually every case off with an ex parte location order. Old habits die hard, and this one has been particularly sturdy, surviving not merely the robust decision of Sir James Munby in A&A, but his equally tough guidance as set out above. The time has surely come to insist that the standard in the practice guidance concerning ex parte applications are scrupulously observed. So I think that also links back to the decision that Simon was setting out, and that was from much earlier. So there seems to be case law that comes into fashion now and again, reminding practitioners of this. I can recall another decision from last year, although it was about non-molestation orders from Mrs. Justice Leven, it related to without notice applications. So that, in a nutshell, in summary, is just to say that you should really think about this question at the outset, as you don't want to be on the wrong side of the decision at the final hearing. The next question that Mani has asked me to discuss is about a disclosure order. What is it, and who can they be done against, and why? So A disclosure order is mainly used when you don't know where the respondent and or the child are. So it's seen as the quickest way to locate them in child abduction proceedings. So usually they are against an identified agency, and you need to have a reason to believe that that specific agency may be able to provide information which may lead to the location of the child. Nowadays, judges are mindful that public bodies have a lot of resource issues, and you really therefore need to justify why it is a certain agency. That particular agency will have the information you require, and that's probably best done in your council's position statement. So in my experience, the most common agencies to seek information from are NHS, Department for Work and Pensions, and local authorities. But you can get creative. It can even be a mobile phone provider, a school, or even a solicitor's firm. So for example, if you know that a particular firm has been instructed by an individual, you can get an order against them, which is quite scary in itself, but it can happen. So it's the quickest way to locate a respondent and a child. But again, you have to be careful. So if you already know where the respondent and or the child is, then you should think twice before making the application for the disclosure order. Just one last point on that, it's really important to make sure that the draft order against these agencies has all the correct information in it. Because if there are incorrect dates of birth, for example, it may not show up on their system and you might not get the information that you need. And I'll just hand back to Mani there.
Yeah, so Forum, so I had a question in advance in respect of the use of wardship, like as a solicitor dealing with this type of work, and in particularly in abduction cases. In what role, in terms of your application, are you seeking in respect of wardship? I mean, what's your views on wardship and the urgency in respect of going for wardship up and beyond? Because these proceedings are under the inherent jurisdiction in the High Court in any event. But does a child always need to be added as a ward to court? You got any views in respect of that?
I think it's quite helpful when they are, but and that's because the court effectively then becomes the legal guardian of the child, and therefore no significant decisions can be made in respect of that child, such as medical treatment, travel, because the court wants to ensure that its ward is properly protected. So where there are concerns about an abduction, for example, if a child has been taken to a non-Hague state, as is common in such proceedings, then his or her return can be sought under the inherent jurisdiction. And it's thought that an order to a foreign court might hold weight if the foreign court then sees that this child is a ward of the English court, when efforts are being made to facilitate the child's return to England. So it's quite helpful in my view. And that is usually discharged at the end of the proceedings. So if the child is luckily returned to the country and child arrangement order proceedings follows, and it doesn't usually carry on from there.
Thanks so much, Forum. Yes, I completely agree. I mean, as when I wrote this book, one of the biggest myths I wanted to deal with is when a lot of people, particularly those who don't do much of this type of work, when they commence proceedings in the High Court in child abduction cases, they automatically go straight for add the children as wards of court, or you need wardship. Now, a child does not need to be added as a ward of court for the inherent jurisdiction to be invoked and to be exercised. Wardship and the inherent jurisdiction are specifically distinct and separate to one another, which is also specified within the family procedure rules. And so that's another tip I would have for the attendees, that when you're seeking particular orders, the inherent jurisdiction is so wide-ranging that within itself can be utilized. But as Forum helpfully outlined, in certain situations of child abductions to non-Hague states, adding a child as a ward of court may have particular persuasive effect or send a very strong message to government bodies or other jurisdictions in respect of how seriously the High Court is treating the abduction. And so it's an extra step, but the powers, the disclosure orders, as Forum mentioned, tipstaff orders, as Simon went through, is all through the inherent jurisdiction. And now, transitioning on from the world of child abduction, I'm now going to go over to Alison, who's going to speak about the inherent jurisdiction in a different aspect, which I think will be useful for the attendees.
Thanks very much, Mani, and nice to see everybody here tonight. Typically, when we think about public law proceedings, we think about care orders, supervision orders, but tonight we're looking at public law in the wider context and at the variety of ways in which a local authority may seek the use of the inherent jurisdiction. It's an area with a huge amount of case law dealing with what relief a local authority can seek. And fortunately for us, Mani's done a lot of the heavy lifting in his book in terms of the case law that he draws our attention to. If statute exists for a local authority to seek particular relief, then they cannot seek relief through the inherent jurisdiction. So the legislation, Section 100 of the Children Act, states that the inherent jurisdiction shall not be exercised to require a child to be placed in the care of or under the supervision of the local authority, to require a child to be accommodated by the local authority, to make a child who's subject to a care order a ward of court, or to confer on the local authority a power to determine any question in relation to parental responsibility. And if the local authority want to invoke the inherent jurisdiction, they will need the leave of the court to do so. And the court will only grant leave if they're satisfied that the result could not be achieved through the making of an order outside of the inherent jurisdiction, and there's reasonable cause to believe the court's inherent jurisdiction is not exercised, a child likely to suffer from significant harm. The case that we'll come back to later is case of Reed T, where Lady Black says that it wasn't intended that the inherent jurisdiction should be entirely unavailable to local authorities, and it's appreciated that there could be cases where it would be necessary for local authorities to have recourse because there was reason to believe a child would otherwise be likely to suffer from significant harm. Before we look at some deprivation of liberty cases, I wanted to first talk about a couple of other areas. So starting with child abduction that we've already heard something about. A local authority can be involved in proceedings relating to child abduction and may be the main applicant. So for example, a child in their care through an interim care order or an interim supervision order may be missing, and the local authority is able to apply to the High Court for tipstaff orders, as we've heard Simon talk about, the location orders, the passport orders, or collection orders. I'm always careful about quoting cases when people on the webinar have been involved, and I suspect there's about at least 2 people that have been involved in this case, which I thought was quite interesting in terms of looking at public law orders and inherent jurisdiction. And it's the case of a city council versus the mother and father, which were care proceedings in 2019 around issues of radicalisation. So there were 4 children subject to public law proceedings. One of the children was 17, so a final care order couldn't be made, but they remained subject to proceedings even though that final order wasn't going to be made. And the inherent jurisdiction was invoked in that case to provide that that 17-year-old's passport was going to be held by the local authority until the child was 18. And that order prevented her from travelling abroad unless she was accompanied by family. And the court found that given the concerns in that case relating to travel abroad, then the order was necessary because there was reasonable cause to believe that that young person was likely to suffer significant harm. And the court went on to say that they were satisfied that the local authority should have been given permission to make that application. The 3 other children that were subject to those proceedings were made subject to a final care order. Another interesting case is the case of the Lewisham London Borough Council and D, which was a 2008 case about the return of a child from the Gambia that was subject to a care order. So in that case, the court couldn't use Section 50 of the Children Act, which is recovery of abducted children, because it wasn't intended to operate outside of our jurisdiction. And so in later cases, the court said that was supplementing the care order that was in place rather than making an order to allow the child to be placed in the care of the local authority. Subtle difference. And then in relation to forced marriage and FGM cases, where I've got particular interest in these, as well as those particular issues potentially being threshold, then local authorities are able to make applications to the court without permission as relevant third parties. And both the Family Law Act for the forced marriage protection orders and the FGM Act of 2003 preserve the right for the court to use any other powers, including the inherent jurisdiction to protect a person. So these orders are wide-ranging and they can contain any prohibitions, restrictions or requirements and other terms that the court considers appropriate. And in the case of a local authority X and others, the court made those protective orders, both forced marriage protection order and FGM protection order, and then made the children wards of court. And that case is particularly good because it gives some core principles around the issues of the inherent jurisdiction. So that's one to have a look at. So moving on to deprivation of liberty. So there is a statutory basis for regulating the use of secure accommodation in respect of children. So we know under Section 25 of the Children Act, a child who's been looked after by a local authority in England and Wales may not be placed for the purposes of restricting liberty unless it appears that they've got a history of absconding and are likely to abscond from any other description of accommodation. And if they do abscond, they're likely to suffer significant harm. Or if they're kept in any other description of accommodation, they're likely to injure themselves. And Re B, where Lord Justice Baker in 2019 distilled the provisions around welfare and proportionality about applying for secure accommodation orders, and said to exercise the inherent jurisdiction in such circumstances where the secure accommodation order is going to be made would cut across the statutory scheme. So if there is a statutory provision, why do we need to consider the inherent jurisdiction in deprivation of liberty cases? So there are many instances which a local authority may want to assist or protect a child by restricting their liberty, but is unable to satisfy some or all of the criteria so as to place the child in secure accommodation. So that means that the option of secure isn't available. And it's not open to the local authority without the authorisation of the court to place a child in a placement that would breach their Article 5 rights. So that's the right to liberty and the security of person. And that's when the inherent jurisdiction is used. So the concept of deprivation of liberty has been examined by the European Court of Human Rights and has specifically been endorsed in our national law by a case called P and Cheshire West. And there are three components. So the component of confinement in a particular restricted place for not a negligible period of time. So this is a difficult question about what is and what isn't confinement within case law. So when does restriction tip into confinement? And it's a case-by-case exercise. So we can look at reported cases. Do staff know where the child's whereabouts is at all times? Any internal or external locks, although the European Court says that lockability is not determinative. And what happens if the child goes out of sight? So in respect of things like use of mobile phones and other access to devices and social media, an example of the court deciding that a local authority with a care order can potentially use Section 33 of the Children Act and exercise parental responsibility to limit the child's use of a mobile phone without needing to invoke the inherent jurisdiction. The second component is lack of valid consent. So a child must be capable in law of providing consent and does in fact give it. And then the attribution of responsibility to the state. So in practical terms, the two most common scenarios when we turn to the inherent jurisdiction are when the child's deprived of their liberty, but the purpose of the accommodation is not deprivation or confinement, but it's incidental to, or where the accommodation is not approved for secure use, but the accommodation affects deprivation of liberty. And we know that there are limited numbers of registered secure beds in England and Wales, and it's made the headlines in a lot of case law in which judges have complained in judgments about the shortage of suitable placements. So Lord Stevenson in the Reed T case said, scandalous lack of provision, and we know that the situation has also been picked up by popular press. So in the case of Lancashire County Council G&N, Mr Justice MacDonald made a decision where the choice was either to refuse to authorise the young person's liberty in an unregistered placement, which would result in her being discharged into the community when she would almost certainly cause herself possibly fatal harm, or to authorise her placement in an unregistered placement that all parties agree is suboptimal because it's the only option available. It's a helpful case because it goes through all of the authorities, and that case the court invoked the inherent jurisdiction, made the deprivation of liberty order, but also directed that the judgment was to be sent to people like the children's commissioners in terms of the state of the numbers of placements available. In terms of practical tips, procedural steps to undertaking applications for deprivation of liberty are set out in that Lancashire County Council case. And at paragraph 38 of that judgment, it sets out what steps need to be taken, which are really helpful if you're the applicant in applying for an order, but also as respondents to be able to check off if all of that information is available. So things like making the court explicitly aware of the registration status of the accommodation, what steps are being taken to have the accommodation registered, what restrictions are going to be put in place, and what steps the local authority is going to take in the meantime to ensure that the premises people working with the child and the care being given to them are safe and suitable. And just a note, it's unlawful and potentially a criminal offence to place a child in an unregistered placement. So it's essential that all parties follow the practice guidelines. You also need to consider whether deprivation of liberty is actually an issue. It can depend on the circumstances of the case and what would be appropriate for day-to-day care. For example, for a 5-year-old is likely to amount to deprivation of liberty, but if applied to a teenager, it may be different things. The National Deprivation of Liberty Court was set up in 2022, based in the RCJ, to deal with applications authorising children having their liberty deprived, and the Nuffield Family Justice Observatory has been collecting and publishing data about the types of cases, and it's probably the first time that we've had an accurate picture of what's been happening to vulnerable children subject to deprivation of liberty. So an increase in the number of older children coming into care, a reduction in the number of children placed in youth custody, closure of secure children's homes, and falling numbers of inpatient child mental health beds have all likely contributed to the increase in deprivation of liberty orders. So just to finish up, that a lot of the law can be found within case law, helpfully summarised, lots of authorities, and can assist us in finding similar cases where the inherent jurisdiction has been invoked or where it hasn't.
Thanks so much, Alison. And I think one of the best things about that particular talk from Alison is it goes on to emphasise how wide-ranging the inherent jurisdiction is in proceedings relating to local authorities, state intervention, public law proceedings, and the vast amount of case law in respect of this area. Now, in respect of the next topic, it is a very interesting, and in my personal view only, a topic that is currently the hot topic in respect of in general proceedings relating to children, but the interplay within the inherent jurisdiction is really important. Now, in the 1980 Hague Convention type of proceedings, there was a joint appeal in the summer to which a colleague at Helen's firm, International Family Law Group, was successful in an appeal. And I was on the other appeal being led by the formidable Mark Jarman KC, who I can see is attending this particular session. And it was a case that provided a significant amount of guidance in respect of the participation of children in proceedings, particularly in respect of when they instruct a solicitor. Now, Helen is hopefully going to talk to you all now a bit about the role of children in this particular aspect. And in the inherent jurisdiction, it is something that is really important because it's welfare oriented. And so the role of children is very much important in these proceedings. So I will now go to Helen.
Hello, everyone, and thank you, Mani, very much for inviting me to participate in this webinar. I myself have purchased the book and I commend it to everybody who's attending this webinar. As Mani says, he's asked me to speak about the role of children in inherent jurisdiction proceedings specifically. And as we've heard from the previous speakers, inherent jurisdiction proceedings are by their very nature some of the most complex family law cases that the court has to grapple with. And in these cases, it's really crucial that the court has the opportunity to hear about the issue in dispute from the child's perspective, be that from the child themselves or by somebody who's advocating on their behalf. As Baroness Hale said, in the case of Reed D, a child abduction custody rights back in 2006, it is the child themselves more than anyone else who will have to live with the court's decision, and therefore the child's role in the proceedings really and truly has to be considered as early as possible in the proceedings. Why is that important? Well, there are several reasons why it's crucial for the court to really grapple with the child's participation in the proceedings, but I'd like to highlight 3 things which I think are particularly pertinent and explain why it can be quite time critical. So the child's own views regarding the dispute should be ascertained as early as possible so they are at their most authentic. As we know, if proceedings get drawn out and if the court invites a child to participate at a later stage in the proceedings, they may well have been exposed to other people's views about the issue in dispute, and the views themselves may not be their authentic views at that late stage. The second reason is that sometimes a child's views on an issue can actually narrow the issues in dispute, and in some helpful cases it can actually lead to the conclusion and resolution, because it can focus the minds of the other parties, principally the parents, if they actually get to hear their own child's perspective on the issue in dispute as early as possible in the proceedings. And finally, as we know, the views themselves have to be factored into the decision-making process more often than not. And therefore, if we can hear those views as early as possible in the proceedings, that can only assist. So as we know that the subject child's wishes and feelings have to be factored in, the principal consideration for practitioners is how should their views be ascertained and what should their role in the proceedings be. And as we know, there are three principal options open for the child to have a role in the proceedings. The first and the most common role is for there to be a report by a CAFCAS officer. The second, and I have to say, quite unusual way in which a child has a role in the proceedings or participates is for them to have a face-to-face meeting with the trial judge. It's an option, but in my own personal experience, it's an option that is not often pursued. The third option is whether or not the child themselves should be afforded full party status in the proceedings and be separately represented with their own legal team. Professionals really need to carefully consider these three options and consider what is the best option, not only for the particular case, but also for the particular child concerned. It will involve the child being interviewed by somebody, and you really have to consider what is appropriate for the child of their age, their circumstances, and indeed the facts of the case that they're going to be asked questions about. As I say, the most often route for the majority of inherent jurisdiction proceedings, in my experience, is for a CAFCAS report, at least initially, to be commissioned. It's important then to really consider what type of CAFCAS report do you need for these particular inherent jurisdiction proceedings. Do you need a simple wishes and feelings report, which tends to be a report that can be commissioned quite quickly, where speed is of the essence, and where the only issue that you really need to ascertain is what the child thinks about the issue in dispute? Or do you actually need a more broad welfare inquiry for CAFCAS to basically ascertain all of the welfare considerations in the welfare checklist? That will traditionally take quite a while. Even in an urgent case, in my experience, even the CAFCAS High Court team in an inherent jurisdiction case will now cite that they need in a region of 16 weeks for such a report. So again, you need to carefully consider what type of report you really and truly need in a case. In the last 20 years or so, I've noticed that there is a general sea change in the courts being much more open to the perspective of and the option of children actually being separately represented in the proceedings themselves, with their own legal team advocating their particular perspective on the issue. I think that this particular shift started in about 2005. There was a case called Mabon and Mabon back in 2005, which was an inherent jurisdiction case. It concerned 6 children, and the 3 elder children of the sibling group were aged 17, 15, and 13. They wanted to instruct a solicitor in the proceedings. And the case, these were private law proceedings, I should say, rather than public law proceedings. They'd approached their own lawyer and they wanted to be represented in the proceedings. And their application was refused at first instance. And they appealed that decision to the Court of Appeal. And it was considered by very heavyweight Court of Appeal, including Lord Justice Thorpe. And it enabled the Court of Appeal to really look at the issue of the separate representation of children in inherent jurisdiction proceedings, one of the first times. And they said at the time a lot of helpful things about the need for children to have a voice and to participate in the proceedings. And they also passed comment that this was not only in inherent jurisdictions cases involving children which were domestic proceedings, but also those broader international inherent jurisdiction proceedings. And I think ever since that decision in 2005, the courts have been much more open to the perspective of and the option of separately representing children in the proceedings. One of the things that CAFCAS officers are often tasked with doing when they are instructed to do a report is to specifically look at the issue of separate representation. Not only to look at the wishes and feelings of the child, but also to consider whether or not the children themselves want to meet with the trial judge, but also to specifically look at the issue of separate representation. So what are the important considerations for us practitioners to bear in mind when looking at the role of children in inherent jurisdiction proceedings? Well, the subject child has the right to have their wishes heard and considered, and therefore we have to work hard to work out what's the best way for that to be achieved. One of the ways in which it can be achieved is by virtue of separate representation. Separate representation can afford the children the voice that they themselves want to have in the decision making, where they are at the very heart of the issue that has to be determined, and they will live with that decision far longer than the lawyers who are ever involved in the proceedings. Part 16 of the Family Procedure Rules 2010 specifically deals with the representation of children. It sets out when the court can make a child a party in family proceedings. And it's very important to bear in mind that inherent jurisdictions fall within the definition of family proceedings for the purposes of that particular rule. And the statutory test for joinder is that the court may make a child a party to the proceedings if they consider it to be in the best interests of the child to do so. So it's not because it's tactically advantageous to the parent that their child wades in with heavyweight lawyers, but actually is it of benefit to the particular child for them to be joined to the proceedings. Practice Direction 16A deals with the representation of children and applies for the joinder of children in private law proceedings, which includes inherent jurisdiction proceedings. I commend the practice direction in its entirety. It's very difficult to really summarize it. I will highlight a few bits and bobs that appear in the practice direction, which I think are particularly important, but it really is something that you should have in front of you when you're considering the representation of children in these types of proceedings. 7.2 states that the decision to make a child a party is always to be exclusively that of the court, and it's to be made in the light of the facts and the circumstances of the court case concerned. It goes on to offer specific guidance on the circumstances that may justify the joinder of children and give specific examples. 7.3 reminds the court and practitioners that separate representation of the child may result in delay. This is where I highlighted that you need to think very hard whether or not you want separate representation or you want a quick wishes and feelings CAFCAS report. Delay is often something to be avoided at all costs, particularly if it's a hot pursuit child abduction case from a non-Hague country. Wishes and feelings report may be actually something that's much more advantageous to get a quick resolution of the proceedings. In my experience, an application for joinder of a child in inherent jurisdiction proceedings is most likely to succeed in a number of instances, and I'm just going to run through them just in case they're helpful for everybody who's attending this webinar. So the first one I want to highlight is when the child does not have a parent who can actually represent their views. Who is the child with at the moment? Where are the parents? If the parents are not the obvious respondents to the proceedings, should the child themselves be a respondent and be able to have their own legal team? Another important consideration is whether or not the child is actually advancing a view and a perspective that can't actually be adequately advanced by any of the existing respondents to the proceedings. So are they the ones that can actually talk about the circumstances in which they lived? And does the parent where they currently are really have no understanding of what they've experienced, so that the child themselves really has to have a clear voice in the proceedings? As Alison said, there are frequently occasions where quasi-public law proceedings, really and truly the child needs to be joined as a respondent to the proceedings with their own legal team in order to advocate, particularly if it's been contemplated that the child is going to be returned to a public body rather than a parent. I've already talked about where the child has their own evidence. I think I covered that with the second point. Sometimes one of the other respondents, and in particular a parent's own conduct, can sort of be so poor that it seems to colour the child's perspective. If the parent themselves has behaved so badly and reprehensibly, but actually the innocent child who's been caught up in the situation has their own distinct perspective, and it would be a good idea for them to have their own legal team so they can advocate separately and distance themselves from the abducting or the parent who's just behaved in a reprehensible manner. Sometimes it's really important for the child to have their own legal team in that instance as well. And finally, sometimes there are rare occasions where the child's own view conflicts with the parent that they are with at the given time. Not only do they have additional information that they can provide the court, but actually they are advocating a solution which is wholly different from the parent in whose care they are at any given time. And that's another, I think, important occasion where separate representation really should be advocated for that child in order for them to really have their wishes and feelings and their perspective on the case heard. Mani has highlighted two recent cases in the Court of Appeal which dealt with the manner in which children are separately represented. In those cases, they both concerned solicitors who acted for children caught up in Hague Convention proceedings. And both cases highlight an important difference in consideration when it comes to inherent jurisdiction proceedings, because in that case, the court had to grapple with a particular lacuna which exists in the rules when it comes to the representation of children in Hague Convention cases. But thankfully, the lacuna does not exist in relation to inherent jurisdiction proceedings. So for the purposes of those attending the webinar, we don't need to really go into the real headaches that the Court of Appeal had to grapple with for Hague Convention cases. That will really be the topic of a different seminar. But for the purposes of today's webinar, where we're looking just at the inherent jurisdiction, what you have to bear in mind is actually a child may conduct the proceedings without a children's guardian or a litigation friend, and may actually instruct a solicitor direct. They need the court's permission to do so, and there are important considerations that the particular solicitor has to bear in mind, but it is an important distinction that when it comes to inherent jurisdiction proceedings, a child can actually instruct a solicitor direct. They don't have to, but it is available to them. If it isn't appropriate, then the court will otherwise appoint a children's guardian to assist with their representation. I think that pretty much covers everything I wanted to say.
Thanks so much, Helen, for that. And I hope all the attendees, have benefited from this particular event today. And one thing just to say as we conclude, firstly, thank you so much to all the speakers. I purposely did not give them all an individual introduction because they've all achieved and been through so much as lawyers in the family justice system. They all are got a tremendous amount of profiles. So I would strongly recommend that you each check them out on their profiles in respect of the work that they each undertake and how much input that they've had to the important cases and cases that we deal with day in, day out. So all the authorities, the appeals in the Supreme Court, Court of Appeal, etc. You would probably find that these 4 individuals and their firms have been involved in some of the leading cases in the field of child abduction, public and private law proceedings. And just to say to everyone, we would be very grateful. If you do have any feedback, please reach out to us individually or collectively. We'll be very keen to know how you all found this particular event. And just a reminder about, I'm giving away 2 spare copies. So any tags or any social media posts, I will choose someone at random. Or as I said, if anybody correctly identifies Simon's age, we've had a couple of guesses at 28 and somebody gets 23, but you're close, but not there yet. So if you do guess it, I will send you a copy of the book.
I think you should give him a book for that, Mani.
Yeah. Thank you so much, everybody, and have a good evening. And thanks again to all the speakers.
Thank you.
See you. Bye-bye.
Bye.
Thanks, Mani. Bye.
See you.